recognize the place of the Dictatus Papae, of the investiture crisis, and the question that then in theological terms is posed to Schreber, which is effectively, where am I? And who am I in this system, and who am I to create? Quod principi placuit habet vigorum legem is the principle that is most at stake. Can the sovereign do what the sovereign will? Can Schreber do what he wishes as Senate's president? Can he make the law? Can he invent? Can he depose? And the answer for Schreber is yes. There's an incredible assertion of juridical theological independence in which Schreber becomes the lawmaker. And what is the project of his lawmaking? It is to make the world in the image of Schreber. Haec imago. He is Christ, and all his suffering is his martyrdom to his unconscious, according to Lacan. All of his suffering is his attempt to embody that impossible unity and that terrible martyrdom that Christ suffered. Why did Christ so suffer? So as to reorganize the relationship between the divine and the human, so as to embody an impossibility that makes us humans possible. So Schreber embodies haec imago, and Schreber invests himself in a trajectory towards the position of character angelicus, the angelic position, the mystic position, the eternal position within the human. That is what tears him apart. What tears him apart is the necessity of interposing himself as Christ interposed himself between the human and the divine. And it is in that interposition that he will save and protect and recreate the world. So we will be born again juridically because of Schreber. He will play the role of Christ. He will sacrifice himself as the intermediary between the divine and the human. So, sub Deo et sub lege, he is persona germinata. He is the carrier of the truth. He is also the creator of the truth. And the only way for that to be possible in the end is for the subject to die. Schreber eventually abandons that position, but his memoirs are expressive of a juridical theology that demands for the human an autonomy and an independence from the divine, that recognizes in Manichaean fashion, in a somewhat Nietzschean way, that we are the will to our own power, and he is the will to his own law. There's one footnote to that, which is that Schreber was an atheist. He grew up not believing in God. He grew up as an Enlightenment figure. And it was only when he was placed in the position of Chief Judge of the Supreme Court, after he had lost the capacity to weigh and balance, after he had lost the capacity to judge, only after that appointment did he believe in God. But he believed in God so as to destroy the effects of the divine in the human. So it's a curious belief. As Nietzsche says, you have to invent God to be able to kill God, but at the same time, he witnessed the manifestations and expressions of divine interference in the juridical, and it was in that recognition that he found his purpose and his project, and that purpose and project was effectively to return to the atheism from which he began, so as to be able to bellow, which is to say, so as to be able to vociferate and to legislate. And we lawyers are so quiet and timid when it comes to speaking our mind and our fears. So if his juridical theology was to take the place of Christ and to interpose himself between the theological and the legal, to protect and act as a barrier between the one and the other, his legal philosophy is simply the mirror of his age, Germany in the 19th century, the trajectory towards the pure theory of law. His legal discourse, in other words, is reflective of his education, it is reflective of his era, and it is reflective of his frustrated desires. So what is his jurisprudence? We find that Schreber studied law the year that Savigny died, the year that Jelinek took over, and the new science of modern law, modern Roman law. The Germans are all for their mos italicus, for prisca jurisprudentia, if that means anything to you. But the unbroken chain, the pure and unadulterated tradition. And that is what Schreber was educated into. And guess what his first job was upon graduating? He practiced as a lawyer, and he practiced in the administration, drafting none other than the BGB, the German Civil Code, finally published in 1900, which is the most positivistic, the most self-contained and autonomous body of law known to humanity. A code that stipulates that it contains everything and that you can never go outside it. If the code is silent, then you apply principles that are parallel or similar or analogous in the code. If the code is silent and there are no analogous rules or statements, then you draw from the principles of the code itself to resolve the problem. You could have no more pure and technicist theory of law. And that is the tradition that Schreber encountered, invented, and entered. That being the case, this self-reproducing system of law seemed to have no place for the judge. And here we need to move. I don't know how much time I have, Your Honor, maybe a few minutes. So, Aufschreib system, the automatic writing system. What did Schreber hate most about divine intervention? Prescription. The celestial figures, the divine amanuenses, all of the miraculous creatures had as their task to write down everything that Schreber said. And that automatic writing system was intended to render his mind blank. If they saw him thinking, they would write it down. And in writing it down, ironically, they would erase it, because they would then say, it's written down, it's written down, it's written down. You can't say that, you can't think that. So his internal monologue went. It's already written. So what is that divine and automatic writing system, but the lawyer becoming an automaton, the divine seeking to make the jurist an automaton, to deprive them of thought, to deprive them of expression, to deprive them of independent action and practice. So, against that automatic writing system and its Grundsprach, I have no idea whether that's right, but it's basic speech, in equivalence to the Grundnorm of Kelsen. So the end of the 19th century, delayed a little while, comes in the form of Kelsen's pure theory of law, a jurisprudence that removes itself from reality absolutely and altogether. It has nothing to do with history, with psychology, with sociology, with reality. The pure theory of law is an architectonic neo-Kantian abstraction that includes no reality or human will whatsoever. It is a Grundnorm that concretizes in a series of lesser norms that are subsumed under the Grundnorm. And one simply has to follow that process of concretization down, but there is no human act and no human will allowed. No interpretation. There is only subsumption within the pure theory of law? Well, the pure theory of law comes as close to the Aufschreib system as could possibly be. In other words, it is that purity, that enclosure, that imprisonment, and that abstraction that turns Schreber into a woman. Because Schreber wants to create, Schreber wants to vociferate, Schreber wants to bellow, and in bellowing to make his own law. So his greatest pleasure then is to contradict that actio in distans of Kelsen and the pure theorists. The as-if of the pure theory of law and of the Marburg Neo-Kantians with a system of images. What gives Schreber the greatest pleasure is picturing. What is his greatest invention? It is the fabrication of images. That is what saves him. That is why he becomes a woman. And of course, in classical law, but I won't bear you with this, a woman is an image. Any of you who are Scottish, read John Knox, the trumpet against the monstrous regiment of women. Woman is an image, and an image is a strumpet, and a strumpet is a woman, and women shouldn't rule, etc., etc. But he has truly become a woman to the Knoxians in this trajectory into picturing, into the imaginary, into his own creation against the will and the tribulations of Kelsen. So his greatest pleasure, and actually this is one of the finest things in Schreber, his hallucinations. He really believes in his hallucinations. Many times he tells the court, if you don't believe that I'm turning into a woman, if you don't believe that I am seeing miraculous things, send doctors, send scientists. They can measure my body. I have breasts now. Don't throw the slogan of hallucination at me, because these are my images, these are my inventions, and these are real. So the pure theory of law is juxtaposed in the end to the pure theory of femininity and creativity. Schreber as a judge of judges. And paraphrasing Freud, then, I would conclude by saying that the question is whether there is more madness in Kelsen's law than there is law in Schreber's madness, because that is, in the end, the question that faces us today. As to Schreber himself, and I will finish momentarily, he was released. Foucault and Laplanche both talk about le nom du père, the no of the father's no, not the name of the father, but the father's no. And there is a certain truth that Schreber's father was a significant cause of what happened. To be a judge, you have to step into, you have to take the place of the father, and if the place of the father is absent and unmodeled, you're going to have a hard time. So I love the fact that the court was very impressed by the fact that Schreber was able to negotiate a contract for the republication of his father's book on mental gymnastics. But here's the interesting part. Schreber had only once referred to and read his father's book on indoor gymnastics. He had gone to that book when he realized he was becoming a woman. And he looked to see whether his father's work on indoor gymnastics had any advice on how a woman should position herself in the succumbing part of sexual intercourse. And the father's book had absolutely nothing to say, no advice to give. So the book had been a desperate failure, and his father had offered no advice on sexual intercourse from the perspective of a woman. Not perhaps a big surprise to us, but a disappointment to Schreber, and yet nonetheless, When the publisher liquidated and he had to find another publisher, he was able to find and negotiate a contract. Not simply otium, but negotium for the new book. Did so successfully and quite lucratively. So that does show a certain cure, a certain solidity, and a certain belief in his own possibility. Secondly, I would suggest that Schreber offers everything that the pure theory and Kelsen lacks. He supplies what is missing. He is the other face of the pure theory of law. He offers a species of lex amatoria, a species of jouissance within the law, which is something that critical thinkers have been trying to do for a very long time. And then finally, borrowing from Nietzsche, his bellowing, his brontological ailment. He was never cured of it. He was never cured of it because up until the end, his unconscious was determined to speak. Thank you.